Live from Washington, D.C., Jay Sekulow Live. Phone lines are open for your questions right now. And now, Chief Counsel for the American Center for Law and Justice, Jay Sekulow.
Hey, everybody, we've got some big news. I mean, a big case that we've been involved in for a number of years. You know the case. It involves the Tea Party conservative organization's lawsuit against the Internal Revenue Service. You know, we represented a total of 38 groups in 22 states from around the country. 32 of the organizations, what are called 501c4, 6 of them 501c3s. These are tax-exempt organizations. To date, the IRS, of the 38 groups remaining, 29 have been approved. But we went to federal court because the IRS was knowingly, willfully, and wantonly violating the constitutional rights of individuals that were basically being targeted. And the IRS acknowledged this. They said it was targeting because it was specific. They didn't like the ideology. They didn't like words like liberty. They didn't words like conservative or constitution. They asked members of these groups who they prayed with. So we filed a massive federal lawsuit. Well, that federal lawsuit ended up getting, portion of it got dismissed at the trial court level, and we were not happy about that. It was the constitutional claim. So what we do at the ACLJ is we filed an appeal with the U.S. District Court for the District of Columbia. That is the court right under the Supreme Court of the United States. In a decision that came out late Friday, the United States Court of Appeals for the District of Columbia ruled in our favor on all, let me say that again, on all of the constitutional claims, saying the case can move forward in the trial court. The dismissal was not correct. The motion to dismiss should not have been granted on what they called mootness grounds, basically alleging that the government alleged that the targeting is kind of stopped, and I'll get into that in the next half hour of the broadcast, in the next segment of the broadcast. Court said, I'm sorry, almost stopping targeting is not stopping targeting. And this was a major win. It's one we fought at Capitol Hill. It's one we fought at the courts, and a good result here, and a great result for our clients as well.
Yeah, that's right. And I think it's going to be important on today's show to explain what happens next. But I do want to make it clear for everybody just the process here. When we take on these fights, and people, it gets a lot of news attention immediately. There's congressional hearings. But then you go to court. And when you really go to court, it takes time. So just to remind people, we filed this back right the same month Lois Lerner announced that this targeting had occurred in May of 2013. And here we are in 2016 in August, and just moving on to that next phase of the trial. And so it's important for all of you to know, when you support the ACLJ and these efforts, that early on when it's getting all the attention in the news, it's important. But then we've got our lawyers and our attorneys in court for years fighting these battles.
I'm going to give you the timeline when we come back to the broadcast of how this started. And it lays at the feet of President Barack Obama. We want you to join with us, stand with us in our fight against the IRS in a case that we now have that's going to be tried before that district court. If you want to abolish the IRS, if you want to stand with us, go to aclj.org. That's aclj.org. I encourage you to sign that petition now, but also let me encourage you to support the work of the ACLJ. As we fight on so many fronts, your support for the ACLJ makes a huge difference. Of course, it's tax deductible, but again, go to aclj.org or call us at 1-877-989-2255. Tell my associate I want to stand with Jay and the ACLJ team. 1-877-989-2255.
It's a significant victory against the Obama administration's IRS. We've been in court for years now, challenging a corrupt IRS that unlawfully targeted conservative and Tea Party groups because of their political beliefs. Now, a federal appeals court has issued a critical decision, clearing the way for us to pursue our lawsuit, to go back to federal court, and to get the truth about this unconstitutional targeting scheme. The fact is, cases like this could not happen without your support. And now your support can truly make a tremendous difference. For a limited time, you can participate in the ACLJ Matching Challenge. If you make a gift now, it will be doubled. $25 becomes $50. A $100 gift becomes $200. Please stand with the ACLJ right now and call 1-877-989-2255. Or you can go online at aclj.org. Thank you for your support.
Hey, welcome back to the broadcast, everyone. So our huge case that we have against the Internal Revenue Service has been around since 2013. It started, and let me give you a context. You'll remember the Tea Party started in 2009, 2010. And it started because CNBC news editor Rick Santelli engaged in a pretty aggressive rant on this was again almost 5-6 years ago against the government spending and the wastefulness of it. So the Tea Party movement started. In 2010, the Supreme Court then announced its opinion in Citizens United, which the president was none too happy about. The president said, do we have this bite where the president says, with all due deference to the separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interest involved in American politics. The next thing you know, that was in January. In February, the IRS begins targeting conservatives. Here's what the president said that started all of this in January of 2010. That's why I say this lays at the feet of the president of the United States.
Last week, the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections. I don't think American elections should be bankrolled by America's most powerful interests.
This was during the State of the Union speech. The next month, folks, not even a month, in early February, I would say a week later, the Internal Revenue Service, we now know this because of the Freedom of Information Act requests that have come out. The Internal Revenue Service begins what they call a BOLO list, be on the lookout list, where they start specifically targeting conservative organizations, pro-life organizations for extra scrutiny if the words Tea Party, Patriot, 912, or conservative sounding names like We the People, Constitution, Liberty were all put up in this, and it took place a week after the president gave that speech.
Yeah, that's right. And what we now know further from these emails is that it was basically the creation of the BOLO was to create a kind of IRS black hole.
Exactly.
And so that these groups would kind of disappear. Their hope was, and as was the case, and I think the IRS actually, their goal, initially they didn't want to get caught, but their goal to stop these groups was pretty effective. So they basically just didn't respond. Well, they first responded with questions that were so out of the norm, they expected many just would say,
who are you praying with?
Yeah.
Who do you...
Website access.
Don't forget that. Complete access to the website.
Log into your back end of your website. So all of every speech, every person who's given a speech, every word that's been spoken at your meetings. We're talking about small grassroots organizations. We're not talking about these mega national groups. Small grassroots organizations. So the idea was we will put them in a black hole, and then they will either not respond, as we know many did not, because they'll be scared. And those who do respond will still kind of just come back with more and more questions and just delay this until effectively we've shut down their organization, which shuts down their freedom of speech.
Which is exactly
and right to organize.
And that's exactly what they try to do. Now, I'm going to get some comments, Logan, from some folks in a moment here with the questions, but I need to let everybody know. We just won at the Court of Appeals a complete reversal on all the constitutional claims where the court threw them out. We are now back in court on that, and the court, very strong language I'll give in a moment. But then let's quickly go to we did this both in the legal sense, and we also did it in the House and the Senate. I mean, it was actually in the House of Representatives where we testified on this. So we dual track this, and then Logan will get some comments from people. I'll let them know the scope of what's happened here.
Well, you ultimately have to dual track it. I mean, you went to Capitol Hill twice to testify. Our clients came up repeatedly to testify. And here's what I think is so great about this win, Jay. You have repeatedly said that the IRS is institutionally incapable of self-correction. Well, this is a long legal way of saying exactly that. They looked at the arguments and said the IRS has a duty to confirm that they have stopped the targeting. They have not met that duty. And, Jay, one other very interesting note. I was in the courtroom that day. You know who else was in that courtroom? Who else knew that this was a significant case? None other than Lois Lerner. So everyone at the agency, both there and past employees, know that this is the way that we can accomplish a real remedy.
I'm going to read some of the comments from let me read one thing, and Logan, then let me get me some comments here. We allege viewpoint discrimination here, that they were targeting these conservative groups specifically because of their viewpoint. Here's what the court said. Viewpoint discrimination is based on the specific motivating ideology or opinion or perspective of the speaker, and therefore plainly offends the First Amendment to the United States Constitution. The court went on to say to process exempt applications pursuant to different standards and at different rates depending on the viewpoint of the applicant is a blatant violation of the First Amendment. The court then held the tax code may not discriminate invidiously in such a way as to aim at the suppression of ideas the government disagrees with. So this is this is just the beginning of it, folks. I got a lot more to cover here. Let's get some comments as well that are coming in, then we'll take a phone call.
Yeah, a lot of people are just calling for the removal of the IRS, the abolishment of the IRS. Yeah. That's kind of the general comments right now. A lot of people said, then what happens next, and will the IRS be penalized for this?
Yeah, they're going to be penalized for it. We're back in the district court, so we've got now to litigate this out in the district court, and we've requested an injunction against the IRS practice, because here's one of the things that's interesting. The IRS was trying to say, well, we've kind of stopped doing this. They said that we self-corrected. Here's what the court says. The IRS offers a rather puzzling explanation for why the continued failure to afford proper processing to at least some of these victim applicants should not prevent a finding of, what the court argued, the IRS argued, was mootness, that the case was over because they had kind of complied. The service brief further illuminates this point, and this is what they said. Under longstanding procedures, the government said, administrative action on an application for exemption is suspended if the applicant files suit in court. Now, understand what the government's saying there. If you challenge the government, we stop moving your application forward. We stop your free speech rights. If you challenge the government. The U.S. District Court for the District of Columbia was not too happy about that. The IRS was engaged in, as the court said, a catch-22. And here's what they said. This is what the IRS is telling you. If we've been violating your rights and not properly processing your application, you are entitled to have your application processed. But if you ask that the processing by way of filing a lawsuit, then you can't have it. We would advise the IRS, this is what the court says, if you haven't stopped violating the rights of taxpayers, then you haven't stopped violating the rights of taxpayers. You haven't carried your burden of proof, be it heavy or light. So this is I'm just beginning, folks, of a complete dispute, not only a disregard for the IRS interpretation, but also a complete disregard for their legal analysis. And the court got it right here. And this is a huge win. We now are back in court, but a huge win. Now, I testified in Congress. Let's play this. Congressman Matt Cartwright, a Democrat member of the Congress, asked me a question.
That's what I said leading into it. It's fair to criticize him for that, but by the same token, let's all stand back and wait till the end of the investigation and reach a measured and reasoned evaluation.
Congressman, I don't have the luxury of standing back. I am in federal court against the IRS. I don't have that luxury. I've got 41 clients. I don't get the luxury to sit back.
And there you have it. And the district court said, well, you do have to sit back. And the Court of Appeals said, no, you don't. And really completely disagreed with Congressman Cartwright, but also very much disagreed with the IRS. And this is the second time, by the way, the IRS has been held in account, just in the District of Columbia, also in a court in Ohio. So we are winning these cases.
Yeah, and it's so important to, again, just underscore the battles, the fights. When you take on the IRS, one, most people are afraid to do that. Two, so we found these brave clients willing to fight back, and we have to underscore that. And three, many of them, they had been completely silenced. Their groups had been almost effectively shut down by this IRS strategy. Now, most of them, we finally got them their approval, but there were still those remaining two, as the court notes. And there were others that just completely dropped out.
We've had some pending for 6 years.
They had nothing left in their organization because they kind of dropped out. But we did have these two remaining who do want to continue their organization and be able to raise funds and comply with the law. I want to make sure everybody knows these are all people, right? Not who the IRS came after, who voluntarily submitted to the IRS oversight. They sent their applications in and said, IRS, we want to comply. We want to do the right thing. We're not just going to be a rogue organization. Right. We want to follow the law, and we want to follow the rules. Here's our information. Tell us what else you need. And the IRS comes back and tells us, we need your prayers. We need all of the speeches you've ever given. We need every email you've sent. We need
every congressman you've talked to, what you said.
To your website access, not to see your website. Of course, that's online, but we need login so we can see all the internal documents. And so again, and these are for groups. I'd say the average of these groups is 100 to a couple hundred members. Very local levels. Average under $100,000 of fundraising.
I am holding in my hand, folks, a copy of the voluminous complaint here. 81-page federal lawsuit. That's what was filed against the Internal Revenue Service here. Here it is. We've got a 20-page opinion rather, from the Court of Appeals. And then quickly here, we fought this very aggressively on Capitol Hill, and Capitol Hill's been waiting for the response. Well, we just got it.
Well, from the very beginning all the way through and afterwards. Remember, Jay, the remedy proposed from the administration was also a violation of our clients' constitutional rights. We made sure to point that out. And by the way, that guidance came directly out of a meeting with the President of the United States. So this went all the way to the top.
Yeah, so the President of the United States started this by a speech, then proposed this fake resolution, which was surrender, if you'll just engage in 49% of your constitutional rights or 40% of your constitutional rights, we'll allow it to go forward. But if you engage in 41%, we're not going to. We said no. And we prevailed. All right, we'll take more of your calls when we come back from the break and your comments as well.
That's right. A couple lines are open. 1-800-684-3110. Those on hold will get to you coming up. But again, 1-800-684-3110.
And don't forget, folks, we're in a matching challenge campaign starting our second week here for the month of August. ACLJ.org. If you want to help us in federal court take down the IRS on this, ACLJ.org. What a great way to do it. We'll be back with your calls and comments at 800-684-3110. But, folks, stand with the ACLJ right now. Easiest way to do it, ACLJ.org.
It's a significant victory against the Obama administration's IRS. We've been in court for years now, challenging a corrupt IRS that unlawfully targeted conservative and Tea Party groups because of their political beliefs. Now, a federal appeals court has issued a critical decision, clearing the way for us to pursue our lawsuit, to go back to federal court, and to get the truth about this unconstitutional targeting scheme. The fact is, cases like this could not happen without your support. And now your support can truly make a tremendous difference. For a limited time, you can participate in the ACLJ Matching Challenge. If you make a gift now, it will be doubled. $25 becomes $50. A $100 gift becomes $200. Please stand with the ACLJ right now and call 1-877-989-2255. Or you can go online at aclj.org. Thank you for your support.
So you remember the apology statement from Lois Lerner? I want to play that. I want to have that one ready to go, and I want her Fifth Amendment. So let's do the apology first.
They used names like Tea Party or Patriots, and they selected cases simply because the application had those names in the title. That was wrong. The IRS would like to apologize for that.
By the way, next time you're audited, tell the IRS you don't have those receipts. You'd just like to apologize about that. Then the famous, she's called before Congress on May 22nd, 2013. Lois Lerner sends an email, actually on the 24th, saying that she would like a job for President Obama in President Obama's Organizing for Action, which is, what is that, is C4, Jordan?
That was his campaign that got converted into one of those groups he doesn't like so much. So it was to convert into what their idea was a constant campaign. So not just having the DNC, but you took your whole Obama-Biden campaign and turned it into a C4.
So she wanted a job there. She says that to an associate of hers. Then, she's hauled before Congress. Let me play it, then get your reaction. This is what she says.
I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations, and I have not provided false information to this or any other congressional committee. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing.
Yeah, well, courts found that it looks like there's been a lot of things committed wrong. So there was the Fifth Amendment. Now, that was not surprising, although the way she did it was completely ridiculous. But then that was, again, if we look at the congressional side of that, we put pressure on in Congress to get oversight here to try to rein in the IRS, which is institutionally incapable of doing that. But it did start this ball rolling and ended up with a lot more information being able to be obtained.
Well, it sure did, and quite frankly, the way she tried to plead the Fifth did as well. I mean, she made an affirmative assertion of her innocence before then deciding to remain silent. That obviously didn't sit well with the committee. But one of the things the committee really focused in on that, Jay, and I know we did on this broadcast as well, is when Lois Lerner did make that apology, she used words like they and the IRS, when in reality, she was the one setting up these schemes and these parameters and these search terms. Yep. And by the way, she did it in conjunction with meetings with the FEC, the DOJ, and the Executive Office of the White House. The IRS chief counsel was at the White House right before those guidance came out. This was a multi-agency scheme. That's why so many committees in Congress were on it.
Yeah, by the way, she didn't know anything about it, Lois Lerner. 15 of the letters to our clients were signed by Lois Lerner. Steve Miller was the former acting IRS commissioner. He wasn't telling the truth either. Here's what he said.
The agency is moving forward. It has learned its lesson. We've previously worked to correct issues in the processing of the cases described in the report, and we've implemented changes to make sure that this type of thing never happens again.
Yeah, here the only problem is, as the court said, and talks about that catch-22 that Jordan likes so much, here's what they say. The IRS only further attempt to justify the lack of its targeting as to some of the applicants is to refer to this longstanding policy that once you follow a lawsuit, we stop. To this, we would advise the IRS, if you haven't stopped discriminatory conduct, the fact that you've been failing to stop the discriminatory conduct for a long time does not create stopping of the conduct. Let me say that again. To this, we would advise, and I'm going to add a couple things here to clarify it for you folks, because it's in legalese, but let me give it to you in English. If you haven't stopped your discriminatory practice, the fact that you have been failing to stop it for a long time doesn't create somehow this, you've stopped doing it. The fact that you have failed to do it for a long time means you are continuing to do it, even though Stephen Miller, the acting commissioner, said you weren't, and that's a violation in and of itself.
Yeah, and I like the catch-22 language which they go on to say the IRS position is reminiscent of catch-22 from the novel. So many of you know that, of the same name. Under that catch, World War II airmen were not required, this is the opinion, were not required to fly if they were mentally ill. However, anyone who applied to stop flying was evidencing rationality and therefore was not mentally ill. You're entitled to an exemption from flying, the government said, but you can't get it as long as you are asking for it. And that's this is from the court's opinion, yes, not our take on their opinion. Their actual words used about what the IRS was doing to conservative Americans.
It's really it's unprecedented in scope and unprecedented in the decision from the District of Columbia Court of Appeals, the U.S. District Court, the U.S. Court of Appeals for the District of Columbia, a major, major win. And I will tell you, they were hard on the government lawyers in the argument, and the fact of the matter is, at the end of the day, they had a big loss here. All right, let's take some phone calls, Logan.
All right, let's go to John, who's calling in Illinois. You're on the air.
Hey, John.
Hello.
Yes, sir, you're on the air.
Great. Jay, with the president being the chief law enforcement officer of the country, he can automatically take office and, as Obama did from day one, declare transformation rather than unity, and then suspend the rule of law through the DOJ and the FBI and all of the other appointed agencies. What's the sort?
Well, here's what you do. This is why we filed lawsuits. Look, when the president tried to stack the National Labor Relations Board, went to the Supreme Court of the United States, we won. When he tried to change the immigration laws of the United States without going through Congress, we went to the Supreme Court and we won. When he had his IRS, and I believe he had his IRS, do this targeting of conservative organizations, and I go right back to that speech that he made, we went to federal court. We didn't win the first level, and we won at the Court of Appeals. So we're back in federal court now fighting this out. So what you got to do is you got to fight back. That's part of the process here.
Let's go Debbie in Fort Worth, Texas.
Hey, Debbie.
Hello.
Yes, you're on the air.
Hey, good morning.
Thanks.
Jay, thank you so much for your show. I appreciate it. Thank you for standing up for our rights. Your talking points are solid facts and meeting up with the constitutional rights, laws, etc. And these governmental thugs need to have their feet held to the fire. And so thank you. Way to go. Great job.
Well, look, we are working hard on this. This is just the beginning of we're back in federal court now, but I cannot imagine how the court's not going to be able to issue an injunction here on this, because the judge's opinion, I mean, folks, we've got analysis up at aclj.org. Jordan and I have just read you portions of it. It is very, very strong. It accuses the government basically of not telling the truth and of continuing the targeting. I mean, not basically. It continues the targeting and doesn't believe anything the Department of Justice laid out. And by the way, as Stan said, this was the IRS, the Department of Justice, the Federal Election Commission, and the Executive Office of the President of the United States. And we are in federal court holding them accountable.
Let's go to Mark in El Paso. You're on the air.
Hi, Mark.
Hey, Jay.
Yes, sir.
I look at this IRS. First of all, you guys are doing a great job challenging these guys.
Thanks.
But I wanted to say, when you stick President Obama's opinion as a lawyer, he's always going to slant it to his preferences, and he's going to move the law whichever direction he wants it to. And then we got to get in the courts and then go through the law.
Well, I mean, but Mark, if we didn't go through the courts here, I mean, elections have consequences. I'm going to Jordan at the end of this. Elections have consequences. You check them by going to court. That's the beauty of a constitutional republic.
This goes to that whole question. We've been discussing this for the years of the Obama presidency: incompetence versus the actual strategy versus this is the goal. And you could look at like ISIS, for instance. You could say incompetent policy, or you could say this is our worldview. We're not willing to engage this way. And I think the call's right. On the legal side of things, yes, President Obama is trying to, you could say it looks like IRS being incompetent, but in fact, it's a strategy that he gives the signal for in his remarks. So, of course, yes, he's trying to push his agenda in a much more aggressive way. And many people misinterpret this as him being a kind of just a bad president, but it's all intentional.
Absolutely.
That's what I think. I think that's the key. This is intentional. This is not incompetence.
By the way, I love this editorial headline in the Wall Street Journal today. The IRS loses in court. Again. Folks, your support of the ACLJ makes a huge difference. We're in a matching challenge campaign as we close this segment of the broadcast out. If everybody here would go to aclj.org, make an online gift to the ACLJ, you're going to keep us in this fight. And the fact of the matter is we are winning this fight. But, Jordan, it's been a big fight. But this continues. I'm going to get more into the particulars on this.
I mean, this has taken significant time. It's taken significant resources. We've had to invest in resources, the ACLJ, because of the tax issues here. It certainly obviously has those constitutional issues, which we know so well at the ACLJ, but then you're dealing with the IRS and their agency and the bureaucracy within. And it was a public battle, and it's been, of course, the courtroom battle as well. And now the battle continues. It's not over, but the battle continues, and the IRS is now under even increased scrutiny. So those of you who want the IRS abolished, this is a great path of way to getting there.
That's going to do it for this week's broadcast, folks. Let me encourage you to support the work of the ACLJ, aclj.org. That's aclj.org. Any match donates tax deductible. We're getting a matching gift for it as well. aclj.org. But also let me encourage you to sign that petition abolishing the IRS at aclj.org or 1-877-989-2255. That's aclj.org or 1-877-989-2255. We'll see you next week.
It's a significant victory against the Obama administration's IRS. We've been in court for years now, challenging a corrupt IRS that unlawfully targeted conservative and Tea Party groups because of their political beliefs. Now, a federal appeals court has issued a critical decision, clearing the way for us to pursue our lawsuit, to go back to federal court, and to get the truth about this unconstitutional targeting scheme. The fact is, cases like this could not happen without your support. And now your support can truly make a tremendous difference. For a limited time, you can participate in the ACLJ Matching Challenge. If you make a gift now, it will be doubled. $25 becomes $50. A $100 gift becomes $200. Please stand with the ACLJ right now and call 1-877-989-2255. Or you can go online at aclj.org. Thank you for your support.